Hi everybody, my name is Alex and I welcome you to a new episode of Deep Tech. Today we will talk about jurisdiction and choice of law in the iGaming industry. Every casino has been in a situation where they have players originating from one country playing on a platform that is located in a foreign jurisdiction. This raises the issue on which law is going to apply, and hence how the iGaming companies are going to implement the technological solution to respect those laws. Deep Tech is a series about technology, but before we can discuss the technical aspects of today's subject, we have to concentrate on the laws that govern them to understand them better. And to that effect, I would like to welcome my guest, Juliette Galea. Juliette is a lawyer based in Valletta, Malta. She has been practicing law for over 15 years, and she has a special interest in interjurisdictional issues. Sorry about that. We invite you to contact her with any questions that you might have at the email address appearing at the bottom of your screen. Juliette, thank you very much for being here.
Thank you, Alex. It's great to be here.
Pleasure. Let's get started. So, first off, maybe you can explain to us what do we mean by the term jurisdiction?
So jurisdiction is composed of three elements. It's a state's ability to prescribe laws, to pass laws. It's the state's ability to enforce laws. And lastly, it's the state's ability to adjudicate. Sometimes it adjudicates on laws. Most of the times it would adjudicate on laws that the state itself has passed, but sometimes in very limited circumstances, it can adjudicate on another country's, using another country's laws. It's a concept which is very closely tied to the notion of statehood. And statehood is, I think, defined mainly through a number of elements. That would be a defined territory, a permanent population, government, and the ability to enter into agreements with other states. Every state has an obligation not to interfere in another state's jurisdiction. Now, this concept of statehood has mainly evolved through customary law, but it was first codified. By codified, I mean put in writing in 1933. And there was a convention called the Montevideo Convention. This was signed in Uruguay by most South American states and also the United States. So, North America. And basically it codified for the first time these concepts of statehood. It's very important because it gives us some guidelines, for example, the equality of states. It doesn't matter if one state is small and another state is big or more powerful, so it's not just about how large the territory is, but also how much power that state yields. At international law, they would be equal players. So it's presumed that within a territory, within a state, a country would, prima facie, on a first glance, on first level, is presumed to enforce its own laws.
That's very interesting because it will definitely apply in the iGaming industry as to where we have players in one country, but often playing on a platform that originates in a foreign jurisdiction. So do these principles still apply today, and do they apply to all states?
Yes. Now, as I was telling you before, the Montevideo Convention was signed in 1933, but it codified, it put into writing ideas that had been evolving for probably centuries. And it was, for example, used in Europe, say in 1991, when a number of EU states were giving advice to former Yugoslavia. There were issues of statehood, when it split up. And they use the principles in the Montevideo Convention. So yes, I would say, because it's customary law, it's applicable to all states.
So based on this, in the gaming sector specifically, how does one approach the situation where there are multiple states involved and multiple nationalities with a gaming transaction?
Okay, so you're going to always depart from the presumption that all states are equal players at international law. So you're not going to say, you're going to ignore everything else and you say, if I've got a big country and a small country, I'm going to put them at par for now. And then you start looking for what we call bases. And there are 5 of them, 5 common ones. So this would tie the event with the jurisdiction of the country, with the country's ability to use its own laws to adjudicate, to enforce the things that we were saying previously. The first base is probably the most important one, and it's territory. Okay, so if a transaction, okay, so for example, in a gaming transaction, you have to see when the transaction is completed and where it is completed. And you'd look at the territory and say, this law in this territory, in this state, is going to apply, okay?
So we're not talking about the country in which the gaming company resides, we're talking about where they're processing payments? Because the company could be in one country, but the payment processing could be done in a different one.
Okay, so this is a contract. So when you're playing, when you're gambling, yeah, it's essentially a contract. So normally, I think you'd have players that would register with a company, and they're going to give a consideration. So they're going to a price for a chance to win. So I think that would be roughly a definition of what's happening. Once those two meet, okay? So there you have the contract. Now, in terms of tech and word that exactly happens online, I wouldn't be able to say. But when those two meet, you have the transaction that is occurring.
So it's basically binding based on the countries where they're located.
That's one basis.
The corporation
now,
itself.
Another basis is nationality. So for example, if I'm in Malta, okay, if the person is Maltese, then even if the transaction happens elsewhere, I would have jurisdiction over that Maltese person because of his nationality, because he's Maltese. Okay, that's a second basis, and it's quite common. It's not as clear-cut as the territory issue, because that's something which is physical, whereas nationality is dependent on more factors. Then thirdly, you would what we call the passive principle. Now, the passive principle is if an action affects a country's nationals. Okay, so they're not doing it, like in the nationality, they're doing the action. In the passive basis for jurisdiction, a country feels that its nationals are being affected. Another basis, the fourth basis, is protectionist principles. So this would include things like national interests or public policy. So a country would say, this action is going to affect my policy, but in quite a close way, so it feels its national interest is affected. And lastly, you would have principles universal basis. These would include really horrible crimes like genocide, piracy, which is less horrible, but horrible nonetheless. Things like slavery, okay, so really crimes against humanity. So I'm pretty certain gaming does not.
Of course. But it's interesting what you're saying, because it definitely helps us understand more how it would work for gaming commissions like the MGA or the UKGC, even though they're not part of Europe anymore. That's going to make it interesting in a legal standpoint.
These principles are they're not just European.
They're universal?
They're pretty universal. So some countries would put more emphasis on one principle than another, but basically I think this is the sum basis.
That's perfect, because it leads me to my next question. Are there common rules or laws that apply to gaming within the EU?
So within the EU, so currently it's 27 members, it's not a harmonized market. So there isn't a law that applies to all states. There are some sectors in the EU which are harmonized. I don't know, like transport is extremely harmonized. So there's common rules applying to all the states. But gaming, no, that's not the case. So if you go in one member state and then you go in another member state, you're going to see different rules. Nevertheless, since the 1980s, okay, so the mid-80s, the European Union has based itself on 4 fundamental freedoms. Now, this would include these 4 freedoms are the freedom of movement, so EU nationals can travel freely from one EU state to another EU state. The free movement of services, which is very important for gaming, okay, because you have a country that is offering its service to another EU country, so it would classify as a service. There's the free movement of capital. So, for example, this would be relevant, I think, also when it comes to winnings, you know. So let's say you gamble in country A, which is part of the European Union. Is it okay then to transfer that money?
It also applies for deposits because it allows a player from one country to deposit funds in an iGaming company that's probably in another member state.
So definitely, you know, there's the entrance point when you're paying, and then there's also hopefully the winnings. Obviously. And the last freedom, which doesn't really apply to gaming, is the freedom of movement of goods. And that's kind of, because persons can apply in the sense, you know, perhaps indirectly, because a company can employ other EU nationals to, like what happens in Malta already. So you've got these 4 principles. Now, the EU has acknowledged, despite the lack of harmonization that we spoke about, that gaming is a legal game economic activity. Okay? So that's very important for the industry. It has acknowledged it, I think, at least since the early 2000s. There are, however, restrictions that would apply.
Yes, so definitely, like, what are some of the restrictions of these 4 freedoms, and particularly in the relation of freedom to provide a service within the EU?
Okay, so when, first of all, different states, as we were saying before, EU states will have different rules. And some states are more protectionist, are more non-gaming. They're not friendly towards gaming than others. And what they often cite are things to do with the fact that gambling is addictive, okay, with underage gambling. And another major concern would be the things to do with money laundering, crime. So these are the things that normally a state would raise in order to curtail its the gaming industry.
Okay, so in that case, how did they come about, the ECJ, how did they come about to decide on which restrictions they would apply?
Okay, so there are about 35 judgments in all. So that sounds like a lot, but it isn't. So that already kind of puts a parameter on the issues at stake. Normally, these would involve things like monopolies. Some states have monopoly in gaming. That's not legal. That has not been declared as non-legal. Neither is the setting up of discriminatory technical barriers. Okay, so barriers, whether of a technical nature, of any nature, which are unfair, which treat local gaming companies differently from other non-national gaming companies. That has also been declared as not compliant with EU law on the basis of discrimination.
Well, you're saying something very interesting, sorry to interrupt, but if I take the case, for example, of Germany, where a state like Lower Saxony decided that they were going to have, as all of Germany in the near future, their own gaming license, and their interest is obviously to sell it, to have control and also revenue from it, they're hindering the rights of gaming companies in other member states, aren't they?
In which way, Alex, would they?
Well, in the way when we talk about these restrictions that they're imposing, but it's like they're trying to supersede the European law.
Okay, so it is okay for a state to have a licensing process, to have a licensing authority to overview this. So this is fine, okay? What mustn't happen is to apply those rules discriminately between your own state's gaming companies and those in other states. So by making them more onerous or making it difficult or in any way different, unless there is a justification. For example, today, if there are barriers or technical requirements for a company to get a license within a EU state, it must notify the Commission. I think Germany has done this in this March. There's a new law underway, and it's seeking to have it, certified as compliant with EU law from the Commission.
Thank you very much for clarifying all of this. Thank you for being here. Now that we fully understand the principles of the law, in the next episode, we will be able to discuss the technical aspects and how to implement them in order for iGaming companies to be able to respect those laws. Thank you for watching, and see you next week for a new episode of Deep Tech.